Hi guys, it's Josh Borman from sydneydrinkdriving.com.au. I just wanted to give you a bit of an update about a matter that I had in Burwood local court last week. It was before Magistrate Sher. Basically, my client had been charged with a low-range PCA offence. His blood alcohol reading was 0.069, which is well and truly in the middle of the low-range blood alcohol reading. He was 53 years old. He owns his own building, design and construction business. He works for himself, having a vehicle and being able to legally operate his vehicle and have a driver's license was extremely important for his work and his ability to earn an income. His traffic history, being 53 years of age, his traffic history was not all that bad. In the last 5 years he hadn't had any entries on his record. He'd been driving since the late 1970s, so he'd had his license for quite a considerable amount of time. In the early days or years that he had his license, he did have a number of entries in his history, in his record, but really over the last 10 to 20 years there's only been about 5 or 6 minor traffic infringements on his history. Now, a traffic history is obviously something that the magistrate will look at and take into heavy consideration when dealing with an existing or current offence before the court. Because my client had a good, strong traffic history, this was well received by Her Honour, in addition to the fact that my client went and completed the Traffic Offenders Program, the fully approved 6-week course at Blacktown, and this is something that he successfully completed to a high standard. He was able to get some character references from people who he has worked with within the building industry. He also got a reference from his wife to give a bit of a personal point of view about his remorse and how the actual offence came about on the night, and a bit of a personal point of view about how being charged with this type of offence has really affected him in his day-to-day life. I got my client to put a statement together by himself to write to the court, and this really came from him, a personal point of view of what he had learnt throughout the Traffic Offenders Program, the solid lessons that he's taken away, and it also obviously showed the level of contrition and remorse that he actually feels in relation to his offending behaviour. This statement was well received by the magistrate because she could actually see the lessons that my client had learned from this whole incident and from completing the Traffic Offender Program. She was happy that he'd taken part in this course and actually displayed the lessons to the court that he had learnt. She took into account his relatively good and strong traffic history. She ended up handing down a good behaviour bond to my client. This was under Section 10(1)(b), which basically meant that he was to be of good behaviour for the next 6 months, and so long as he was to remain of good behaviour and not be charged with any other offences, he wouldn't be convicted of this low-range PCA offence, and he would also be able to maintain his ability to continue driving, so his licence was not disqualified. My client was absolutely over the moon with this result. It was the first drink driving or major traffic offence he had ever been involved with. It was a very stressful period, and he was really facing a huge loss of income and business if he was unable to drive. So being able to learn the lessons that he did from this incident, and also being able to continue to earn an income, was the best result we could have got him, really. So he was rapt, he was over the moon. I sincerely believe that it's been a life lesson that he's learnt, and he's the sort of person at the age of 53 who has committed this one-off type of drink driving offence will not be back before the courts again, and I certainly hope that is the case. So that was a good result. I just want to say to anyone out there who has been charged with a drink driving offence or an alcohol related traffic offence, there is help out there. It can be a very stressful and trying period to go through, and a time where you simply don't know what to do. But if you have got a charge of a similar nature against you, then I would recommend that you go to our website, which is sydneydrinkdriving.com.au. There's plenty of information there about the laws, offences, penalties, and a raft of other issues surrounding drink driving offences in New South Wales. Have a look at that, read up on the articles and the information provided there. Then you can give us a call at the office. Our office number is 02 9283 8622. You can ask for me. My name's Josh Borman. I'm the head of the traffic and drink driving department here at Beazley Singleton Lawyers, and I'm happy to have a chat with anyone who has been charged with a drink driving type of offence. A free telephone consultation just to give you a bit more insight as to what your current situation is and what you can expect when you go to court. If you want to get us on board, we'd be happy to represent you as well. We charge a very reasonable fixed fee rate of $1,500 plus GST, so in total that's $1,650, and basically that will cover your entire matter right through to we get a final court result on your matter. Obviously a license can be a very valuable thing to maintain, and for people who have been charged with drink driving, it's critical that they can get back on the road as soon as possible, usually to continue to earn an income, just like my client was able to last week when we attended Burwood local court. So please visit our website, sydneydrinkdriving.com.au, and if you've got any queries or questions, call me at the office 02 92 83 8622. Thanks guys.